Hello everyone, this is Melanie, and this video is here to help you with some of the solutions for the law questions for this chapter. So some of the information isn't quite clear. A lot of the questions and answer choices for this chapter, you kind of have to interpret the information in order to apply it to the questions. So we find that a lot of people have troubles, and we thought that this video might help. So this first question says, any clause contained in a mortgage which clogs the equity of redemption is what? So the answer to this one is if any clause mentioned in a mortgage, and when you see the word mortgage, you have to remember that it's talking about a contract, okay? So the mortgage is the contract, and the loan that actually is given for the property is in relation to that mortgage contract. So just think of mortgage and contract as interchangeable words, okay? So any clause that's contained in a contract which clogs the equity of redemption, it is going to be void. So that clause is going to be void. Now, if the whole mortgage itself, if the whole contract itself somehow clogs the equity of redemption, then it will also be void. Okay, and so what are they talking about when they're saying clogging the equity of redemption? What is that all about? So remember, when you have your first legal mortgage, the equity of redemption is related to that first legal mortgage. And what we say about it is that when you pay all of the obligations that you promised in relation to that mortgage contract, okay, so in relation to that first legal mortgage that you were given, if you pay all of the obligations, you pay all of the interest, and you pay back all of the principal that you borrowed in the first place, then you have the right of your equity of redemption. You have the right to redeem your property free and clear of that charge, of that mortgage contract being charged to your title. So if your equity of redemption is clogged, if someone is blocking your ability, is not allowing you to actually redeem the equity in that property, then it's considered to be a void contract or a void clause. So basically, you aren't allowed to block or clog someone's ability to get to that equity of redemption because that is a right under the law. So you can't stop somebody from being able to access their legal rights. Okay, the next one says after a borrower has given a mortgage of real property, the borrower's remaining interest is described at law as what? So again, when you are giving that mortgage contract to the lender, so the borrower has given the mortgage contract to the lender, what is their remaining interest as per the law? And their remaining interest, again, is that equity of redemption. So again, they get to redeem their title free and clear once they've met all of the obligations that they promised to meet in that mortgage contract. So this question is a little bit trickier, and it's more of the answers are trying to mislead your thinking in interpreting the question itself. So the question says, after the contractual right to redeem has passed on a mortgage, then what happens, or what occurs, or what is present? And the answer to this question is number 3, that an equitable right to redeem still exists. So what is the question actually kind of spelling out for you? What is the picture? What is the event that's happening? So after the contractual right to redeem has passed on a mortgage, so contractual right to redeem is related to the term length of a contract, of a mortgage contract. So when you go to, Royal Bank or CIBC or Dominion Lending or whoever it is that you get your mortgage from, your mortgage contract and the loan from, you will actually you will bind yourself to that lender for a term length. So we have amortization and we have term when we talk about mortgages. The amortization is the total amount of time that it's going to take for you to pay back that principal, for you to pay back that present value that you borrow in order to make that property purchase. The term length is much shorter than the amortization because the term is the length that you're contracted to that specific lender for. So you might have term lengths of 1 year, 2 years, 5 years. You could even have them for as long as 10 or 15 years, but usually when you're just starting out your relationship with that lender, maybe it's your first property purchase or the first time you've had a mortgage on that property, the term length tends to be quite short. It tends to be 5 years or less, and it really also depends on what type of mortgage you get, what type of terms you get on the loan that's related to that mortgage. So the term length, if it has passed, if your right to redeem has passed, this question here, this statement isn't saying that something has gone wrong. It's simply just saying that the term length is done, it's up, it's run its course, and we have the ability to either negotiate for a new one or to somehow pay out the entire amount of principal, PV, that we've borrowed to purchase the property. So when you have this term length done, so let's say you have a 5-year term with your bank for the first mortgage on your property, once that 5-year term is done, you have that equitable right to redeem, because once you've gotten to the end of that term, you've paid off all of your obligations, you paid off all of the interest that you promised to pay that lender based on the money that they loaned you. So your equitable right to redeem still exists. Now, if you look at answers number 1, 2, and 4, they're all kind of in the same topic area. And when you read them, you kind of get the sense that they're talking about foreclosure when they say that the borrower must give up the mortgaged property. Okay, so you're going to give up the property. The lender becomes the owner of the mortgaged property, or the borrower owes a higher rate of interest on the arrears. So these are all referring to foreclosure situations. And the thing that I want to caution you on is in the actual question, so in this statement here that it starts you out with, it says nothing about the borrower defaulting. It says nothing about the borrower missing payments, and it says nothing about a foreclosure situation. So numbers 1, 2, and 4 are trying to sort of mislead you and get you to misinterpret the question itself. But this is just saying that the normal term length has run its course, and now the equitable right to redeem still exists by that borrower. They have the right to redeem their title free and clear of that charge if they've met all of the obligations in that contract. So when a mortgagor grants a mortgage subsequent to a first registered mortgage, the mortgagor has created what? So again, you've got to pay attention to the terms in here. So what did we say about the word mortgage? That it's the contract, right? There's a loan that is related to it, that's given in relation to it, but it's a contract. Now, the mortgagor is which of the people? We have to know who it is that it's related to. So for this one, the mortgagor word has 2 O's in it. Okay, so 2 O's are there. You can't really see that highlight so much, so I'll do that. And mortgagor and borrower both have 2 O's. So that's how you know who they're talking about. Mortgagee is the other person that they're talking about. So mortgagee, and it has 2 E's in it, and lender also has 2 E's in it. So these two are the same thing, just as borrower and mortgagor are the same thing. Okay, so this question is referring to the borrower in a lending situation. So when they grant a mortgage that is subsequent to a first registered mortgage, so a first legal mortgage, a first mortgage, a legal mortgage, they're all the same thing. Okay, so a first mortgage is the one that is for the most amount, right, that you've borrowed, and anything after that becomes an equitable mortgage. So subsequent means you've granted that mortgage after, secondary to this first registered mortgage. And so you've created an equitable mortgage. So it could be a second mortgage, right? Could be any other number but one. Any other number but first means it's an equitable mortgage. And then you had all of those other named mortgages that you went through on your list as well. So if you can't remember those, if you don't know the difference between a first registered mortgage and an equitable mortgage, then I would suggest you go back to your videos and your notes and you review that. So which of the following statements regarding mortgages is true? So we're looking for the true answer in the list here. So the first one says an acceleration clause allows the lender to accelerate the expiry of the term of the mortgage and demand repayment of the entire loan amount provided that the borrower is given 3 months notice. Okay, so the false part of this is the requirement for that 3 months notice. Most of the time acceleration clauses will give you 7 days to sort out the financial shortfall. So if you've defaulted on your mortgage and you haven't made some payments, then you're given about 7 days to get that sorted. So that is not our answer. Number 2 says upon the execution of the mortgage contract, so upon actually registering it and letting it go forward, the lender is required to advance the total amount of the mortgage immediately regardless of the terms of the mortgage. So the false part here is the immediately and regardless of the terms part. The terms of a contract actually tell you what your rights and privileges are based on whatever is agreed to in that contract. So the terms would actually say when the money would be released, and most of the time there's a specific timetable as to when that's going to happen. So that is not our answer. Number 3 says under the Property Law Act, the lender cannot require the borrower to obtain the advance consent of the lender before making any alterations or improvements to the property. That is a false statement because it says they can't require the borrower to have to get permission from the lender. The lender absolutely can require permission for certain alterations or improvements, especially if they put that in the mortgage contract, then that would be something that you would have to adhere to. So a lot of times the improvements on the property or maybe just the state of the land itself is where the value is, where a lot of the value is in that property. And so if you are going to make changes to that, then the lender will want to know because they've loaned you money based on the current state, and if you go and change that, then it might change their mind on how much they would be willing to actually lend you. So because all of the first 3 are false, we know that number 4 is our true answer choice. So the mortgage contract, in addition to the common law, so remember, just because we have the common law and changes made to it through statute law doesn't mean we throw it out. We actually follow the common law every day. So the mortgage contract, in addition to the common law, provides the lender with a number of options and remedies to pursue when the borrower defaults on the mortgage. So it's up to the lender to choose the remedy it feels is the most advantageous in the circumstances. That is absolutely true. So with respect to the application of the Environmental Management Act, the EMA, to mortgage, which of the following is true? So number 1 says lenders can face liability under the EMA if they become registered owners of the property as a result of foreclosure. So I apologize, there's a typo here. This should say they. So that is absolutely true. If there's a foreclosure situation and the borrower defaults and doesn't make their payments and the bank eventually puts the property in their name, then they are actually liable for the property under the EMA, so for contaminations, that sort of thing, if they become the registered owner. So the wrong parts, the incorrect parts of all of the other answer choices, you need to pay attention to, just in case they change this true question to a which of the following is false question. You need to be able to understand that these are all false answer choices, and then that could become the correct answer. So the EMA automatically makes a lender partially responsible for environmental contamination of a property if the lender's mortgage is registered on title at the time of the contamination. This is false because if you remember from the details on this subject, if the lender is just taking part in financial stuff, if they're just providing cash for the loan, and the mortgage is registered on title at the time of the contamination, it means that they lent the money they charged that mortgage contract onto title long before the contamination happened. Then the lender shouldn't be held responsible for it after the fact. Number 3 says lenders can file a notice with the EMA before providing mortgage proceeds, directing the Director of Waste Management to conduct an environmental assessment of the subject property. So they can require an environmental assessment of the subject property, but the Director of Waste Management is not the individual that would do that. You would hire, the buyer would probably be required to hire a company to come in and do an environmental study on that property to make sure that there was no contamination before the lender will actually provide the loan monies to purchase it. Number 4 says the EMA has no application to mortgages, and we know that that is absolutely false because sometimes the lender will actually be liable based on the situation that's happening, and sometimes a lender will not actually want to loan monies if there has been a contamination. So number 4 is also false. Which of the following statements regarding a due on sale clause is true? So you have to remember what the details were about the due on sale clause in order to know what the answer is. So this was the one that allows the lender to collect all of the monies that they have basically coming to them that they can claim. So all amounts owing under the mortgage, so all the interest, and then if there's prepayment penalties, as well, if the person wants to exit the mortgage before the term is up, then they can actually collect those as well. So number 4 is actually the correct answer for this one. So what is wrong with numbers 1, 2, and 3? A due on sale clause provides that when a property is sold, the buyer of the mortgage property has the option to assume the mortgage. So the due on sale clause is not for the benefit of the borrower. It's for the benefit of the lender. So it's got nothing to do with allowing purchasers to assume the mortgage. It's to allow the lender to basically collect on those monies, right, that they have owing to them. So if a mortgage contains a due on sale clause, and any outstanding balance on the mortgage must be assumed by the buyer of the mortgage property, that is not true. The seller would have to be dealing with any outstanding balances, particularly if it's in the form of mortgages or liens or any of that kind of stuff. If the mortgage contains a due on sale clause, the borrower cannot sell the mortgage property without written approval from the lender. That's false. And the reason for that is because the due on sale clause protects the lender. It is the thing that protects the lender. So the borrower can sell the property. They would just have to pay all of these amounts that are laid out in the contract based on the due on sale clause. And then the last point that you need to remember about the due on sale clause is that it gives the lender approval rights if the new buyer, if the new owner wants to assume the mortgage terms that are already present in the form of a mortgage on that property. It gives the lender approval rights as to whether to say yes or no to that potential buyer, to that potential owner. So they have the right to collect from the person who already has that loan. So the current owner who is selling, they have the right to collect all of those payments and penalties and that kind of stuff. And as well, they have the right to say yes or no to the new owner, to that person who wants to buy the property, as to whether they can assume the mortgage or not. Okay, so this question can be confusing for people. So the key here is who it is that is being talked about and who the question is being asked about. So the question says the process whereby a mortgage lender transfers his interest in a mortgage to a third party is known as what? And a lot of people think that, it's going to be an assumption because they're talking about a mortgage, and it's when one person takes over a mortgage, it's an assumption. And that is wrong for this question. That's incorrect for this question. For this question, the correct answer is that if one lender is giving their contract is more than likely selling, so they're transferring their interest by selling that mortgage contract to somebody else, that they're allowing that person to take over that contract, and that would be an assignment. Okay, so let's go through some facts and kind of figure this out. Okay, so the difference between the assumption and the assignment is really important. So let's go over some facts and then we'll kind of sum it up and wrap it up. So when you assign a contract from one person to the other, you have to remember you can only assign benefits. You can't assign any liabilities. So for lenders, when they give monies, when they give a loan to a borrower and they receive that mortgage contract, they are basically in the position of power. And the reason why I say that is because they're only going to benefit from that contract, because the borrower has to pay all of that interest to the lender. Borrowers, however, have both benefits and liabilities in that mortgage contract. So yes, they have the benefits that are laid out there, but the thing that kind of limits them from being able to assign that mortgage contract to somebody else is the fact that they have liabilities. So they have to pay interest as one of their liabilities in that mortgage contract, and they can't actually assign that responsibility. They can't assign that liability to somebody else because they are the ones that promised to pay that interest. So a lender can actually assign their mortgage contract to another lender. They just sell that mortgage to a different investor, and that investor now becomes the new lender in that relationship. So the borrower's position doesn't change. The contract stays as it is. The borrower pays all the same interest and lives up to all the same promises that they made in that contract. And the only change is that the mortgage contract was sold from one investor to another, and it's just now a different lender that's on that contract. Borrowers, like we said, they can't assign their mortgage contract to another borrower because the contract is first based on the individual and can't be transferred, and because you can't actually assign your liabilities to somebody else. They can allow another borrower, so a new owner, to assume the mortgage terms of the first borrower, but when somebody comes and assumes your mortgage terms, a new contract is written, and that's through the whole process of novation, which we'll get to in a few moments here in another question. So it's really important that you know the difference between assumption and assignment and who can do which one. Borrowers can allow an assumption, and lenders can allow an assignment of that mortgage contract, but not the other way around. So when the original loan agreement between the lender and a seller of property is replaced by a new loan agreement between the lender and a buyer of the property, so somebody who's going to be the new owner for the mortgage debt, what legal concept has occurred? This is novation. So basically what is happening in this question is one borrower, the buyer, is now going to assume the seller's terms, and so what is happening here is novation. So what is happening here in this assumption situation, okay? Remember, this is not an assignment, this is an assumption. So it's all about the relationships and the who is who in here. So you have the original buyer and the lender, so the original owner and the lender that agree on a mortgage contract. So they actually forge a contract for a mortgage loan on a property. So the original owner then wants to sell their property, so they become the seller, and they sell to another person. They sell to someone else. They're going to be the second owner and the buyer of that property. Now that buyer, they like the terms of this original contract. They like what's in here much more than what they would get if they negotiated for a brand new contract at the current rates. So maybe the interest rate is really low, or maybe it's a longer amount of time that's left on the term and they like that. Whatever the case may be, they want to assume the original owner's terms. So when they assume that mortgage, then a new contract is made between the second owner and lender that's based on the original owner's terms, and we call that novation when one contract is replaced by a new contract. So when one loan agreement is being replaced by another loan agreement. So remember, this is not assignment. You can't assign a mortgage from one borrower to another. You can only assign from one lender to another. And we say that novation has occurred here because a second mortgage contract replaced the original mortgage contract. Okay, so this question says describe the best answer in regards to the steps in foreclosure. So I've scrunched them up here because I'm going to add some information underneath, but basically each of these answer choices gives you 4 out of the 5 steps for you to identify, and you need to identify them in order. So it doesn't say that in the question, but that's what they want from you. They want you to give it to you in the proper order. Okay, so you need to know the steps in the foreclosure process. There are 5. Now, when they only have 4 listed, so they only have 4 steps listed here in all of the answer choices, you need to understand that if they don't have, for instance, if they don't have this demand letter mentioned in any of the answer choices, then you need to remember that the order in the answer choices would start with a petition, then would go to the petition hearing, then would go to the order nisi, and then would end with either an order conduct of sale, a judicial sale, or the order absolute of foreclosure, okay? So you just kind of have to use common sense in order to figure out what is correct and what is not for this one. So let's look at each of the answer choices here. So we know that the demand letter is the first step. So that has to be in the first position always for this one, if it's mentioned in the answer choice. If it isn't mentioned in the answer choice, like I said, then you would only have 2, 3, 4, and 5 mentioned. So any place other than first for the demand letter would make that answer choice false. So for that one, we know 3 and 4 are false because the demand letter is listed as either the third or the second step. For the petition, if it isn't after the demand letter, or if it isn't in the second spot, in the second step, then we know that it's actually false. So for this one, the petition is in the third spot, and you see that the petition is listed after the order nisi, and the order nisi is actually down in the 4th spot here. So you know that that one is actually false as well, because nisi should be after the petition. So by that, we actually know then that number 2 is false, and we have a confirmation that number 4 is false because now we have 2 things that are incorrect about number 4. So the petition hearing should be in the middle. So it shouldn't be in the first spot, it shouldn't be in the last spot, and we see that the petition hearing is actually mentioned in answer number 3 in the very first spot. It's not mentioned anywhere else. So we have confirmation that answer number 3 is false a second time. So the petition hearing, again, it does come before the order nisi, but it would never come before the demand letter. Okay, that's why number 3 is false. Then you get to the order nisi. This is where the first court order happens. That's the order nisi with a redemption period. So if the order nisi is listed as the first step, then we know that that is incorrect. So we have another confirmation that 2 and 4 are false. And the order nisi here is listed as occurring before the demand letter in number 3. So again, we have another confirmation that number 3 is false. Then you get to either an order conduct of sale or a judicial sale. That's the more common term. Or an order absolute of foreclosure. So I didn't put that in there because they don't always mention it, but order absolute of foreclosure is the full phrase. So order absolute of foreclosure here is all in the last spot, so that's all good, that's all correct. But the judicial sale is listed in this case in the third spot right in the middle, as well as the order absolute of foreclosure. And this one is the problem because it's either or. You wouldn't do the judicial sale and then do an order absolute of foreclosure. So number one is the only possible answer choice that we have for whatever the 15 different reasons that we just mentioned. Okay, so if you know that order, these are great questions to get because there are so many ways that you can confirm that an answer choice is false. Now, just a few little points about each of the steps here. The demand letter usually gives a period of about a week or two once it's sent out to that borrower who's defaulted and not paid. So they have a week or two to get their financial situation in order. Then the lender, if they don't get it sorted, then the lender would submit that petition in order to get the petition hearing. And then at the petition hearing, they would ask the court for that order nisi. The order nisi is usually about 6 months. So this one, that's why we call it the order nice guy, if you remember from our lectures. So the order nice guy, we called it because it gives a pretty decent amount of time in order to get the financial situation sorted, to get your property on the market and sold so that you can actually meet the obligation and pay out what you owe to your lender. And then if you don't get that order nisi met, if you fail to pay the debt, then we would go to either the judicial sale or the order absolute as the final step, and the court would decide whichever one they felt was most appropriate for the situation. All right, so because we just went over the 5 steps of the foreclosure process, this should be pretty easy for you. So in a foreclosure proceeding, the court order that the lender most commonly seeks at the first court appearance is, and that would be your order nisi. Okay, so it's really important for a bunch of different reasons to know all 5 of those steps in the foreclosure proceedings. Okay, so when an order absolute of foreclosure is obtained by a petitioner who is in position of second mortgagee, then what will happen? Which of these sentences will actually finish off the sentence and be true? So you have to remember, mortgagee is referring to lender, right? 2 E's in mortgagee, 2 E's in lender, and the petitioner is also always referring to the lender. And it says here that there's an order absolute of foreclosure that's been obtained, so it's been gotten by the lender in a court. So they're pursuing that order absolute path, which means that there's lots of equity in the property. Okay, so there's a ton of equity that's in the property. And what happens when we get to the order absolute? The lender gets to put the property in their name, so they get their name on title. But because they get their name on title and they get to claim all of the money, all of that excess, all of the equity that's in that property because their name is on title, they actually do not get to go after the buyer on their personal covenant. So they do not get to sue the buyer on their personal covenant because their name is on title and they get to claim all of the equity in the property once the property is sold. So number 1 is false because it says that the lender has the right to sue the borrower on their personal covenant. That is false. Number 2 is false because it says that they can sell the property after taking title to it, but they'll have to account to the borrower for any profit that is realized in excess of the mortgage debt. That's false. The lender gets to keep all of the excess, all of the profit which is realized. Number 3 is kind of tricky because it uses some official words, some legal words, and you think that it sounds good, but it's actually false because it says all other charges, liens, encumbrances, and interests registered on the borrower's title are foreclosed or wiped off the title. So we don't wipe anything off the title. We're not foreclosing other people's charges, liens, encumbrances, interests off. We're just petitioning the bank to actually get ours taken care of. And there's something that's called the order of priorities when we talk about mortgage contracts. There's a little bit more detail to that, which I'll cover off in a different question in a different video. But what you need to know is that it doesn't automatically mean that when a petitioner is going through the order absolute, it doesn't automatically mean that everything else is taken off title and they're the only one that is important. So that means that number 4 is the true answer choice. It means that the order forecloses the registered owner's interest. So this is the buyer, right? It forecloses the buyer's interest. The buyer's name gets taken off the title of that mortgaged land, and it permits the petitioner to transfer title into his or her own name. Okay, so this one is a pretty simple, easy question. It says Jordan has granted Mary a mortgage over his property, Blackacre, and one of the terms in the standard mortgage contract that they execute allows Mary, aside from pursuing a foreclosure, so aside from pursuing sort of the regular means of getting her money back as a lender, it allows her to exercise the remedies of an ordinary creditor if Jordan defaults. So if Jordan defaults and Mary pursues this option of an ordinary creditor, then she'll be taking action on what? And so ordinary creditors, they always rely on the personal covenant. They always rely on a person's promise, sort of under the law, to repay whatever debt that they owe, whatever promises that they've made. So number 2 is the answer. So now let's go through all of the other answer choices that aren't correct so that we can test our knowledge and make sure that we understand why they are not one of the things that she would pursue. So the first answer choice says it's the order nisi that she would be taking action on, and that's not true because the question says, aside from pursuing foreclosure, and the order nisi is part of that foreclosure process. It was the 4th point, the 4th step in that foreclosure process where you were at the petition hearing as the lender asking the court to grant that order nisi. So number 1 is not the answer. A collateral advantage, this one is related to clogging someone's equity of redemption. So blocking someone's right to redeem a mortgage free and clear of a charge for that equity of redemption. A collateral advantage is one of the things that's a possible clog. So that one is also not something she would be pursuing because it's not about a creditor being able to collect from someone who owes them. And number 4 is about priorities, and what that means, what that's referring to is whoever has charges that are registered onto the title, that are charged onto a property title, they have an order of priority based on all of the laws that you see here that are listed below. As to who gets the priority in the lineup, who gets to claim their money first in line. So if you notice that a lot of these things here that are mentioned, like the Workers' Compensation Act, the Employment Standards Act, the Local Government Act, Community Charter, Income Tax Act, Canadian Pension Plan, the EI Insurance Act, and Excise Tax Act, those are all government-related type laws. So do you think, if I were to ask you, do you think the government would take priority over a lender, over a registered mortgage? The answer is always yes to that. So the government would basically jump the line and they would get first dibs. They would get first claim to any monies that might come out of proceeds from a sale. Now, this is not the priorities is part of sort of contract law, and so lenders, they get an order of priority, so they're put in order of priority, as well as the government just automatically gets put in priority. So that's not the remedy of an ordinary creditor, and that's not what this question is referring to. So basically what the priorities is about in general is when a mortgage lender decides to to pursue a foreclosure, and they get that foreclosure process happening. If they get to the point where they go for that judicial sale or the order absolute of foreclosure, they may not be the first in line to actually collect whatever is owed to them if some of these other items are charged onto the title. So if there's a builder's lien that we see here under the Builder's Lien Act, or if there are unpaid strata fees, those will jump the line in front of that mortgage, even though the mortgage may have been registered, 5 or 10 years prior to the building lien or to the unpaid strata fees lien. Employment standards, workers' compensation, local government act, excise tax act, all of those things are all government related. So again, the government would jump the line and they would take priority over that registered mortgage. Now, you're not going to be asked to prioritize these. You're not going to be asked which one would get first place, would be able to come in and get their money first. You don't need to worry about that. You just need to sort of know in general what the priorities is about, and that there are certain things like these items that would take priority over a mortgage. That's all you need to know. So hopefully you found that helpful if you were struggling with this area of your course, that now you have the information that you need and a little bit more knowledge in order to be able to answer the questions with a little bit more confidence. Thanks for watching, and I will meet you in the next video.